Welcome back to PittsburghNORML Presents. Today we're talking about citizen police encounters and your rights under the United States Constitution and the Constitution of the Commonwealth of Pennsylvania. When can police stop a person and when can they search them?
Police-citizen encounters is governed by the United States Supreme Court case of Terry versus Ohio. Terry versus Ohio sets forth 3 levels of citizen police encounter: the mere encounter, the Terry stop, and the arrest. A mere encounter does not need to be supported by any suspicion whatsoever, but the citizen in that situation is free to leave and an officer may not detain them. A Terry stop is where an officer can briefly detain a citizen, an individual, while investigating a crime. That officer must have reason to suspect that the individual may have been involved in the crime. That officer, in other words, must have reasonable suspicion, and the detention cannot last any longer than is necessary to either dispel that officer's suspicion or allow it to ripen into probable cause. Probable cause is required for an arrest, and the concept of probable cause is that the officer, when considering the officer's training and experience, has reason to believe that a crime was committed and that the citizen, in fact committed the crime. At that point, an individual is subject to arrest. The right to search under Terry versus Ohio is fairly limited. The right to search is only if that police officer has articulable facts to believe that you are armed and dangerous during a Terry stop. In that situation, the officer may pat you down for weapons. Otherwise, you cannot be searched by a police officer unless you are actually physically under arrest. Often we've encountered officers saying, well, I want to search you for officer safety. Well, that exception does not exist pursuant to Terry versus Ohio. A blank assertion of officer safety without those articulable facts to support a conclusion that the citizen is armed and dangerous will not permit an officer to conduct a pat-down of your body.
Do you have a right to refuse to consent to a search of your person or of your vehicle?
Absolutely. The Constitution of the United States and the Commonwealth of Pennsylvania guarantees you the right to refuse to consent to an unreasonable search or seizure. Often when police officers are investigating a crime, they understand that the quickest way to find out whether or not there's contraband either on your person or in your vehicle is to simply ask you for consent. Whether or not they have reasonable suspicion or probable cause, they can certainly at least say, do you consent to a search of your vehicle or your person? And if you say yes, then you're giving up critical Fourth Amendment rights. You have a right to refuse to consent. The officer does not have to advise you that you may refuse to consent, and you must affirmatively state that you refuse to consent.
What happens if the police do violate your rights?
If evidence is obtained from you, if contraband is obtained from you in violation of your constitutional rights, you may move to suppress that evidence in the Court of Common Pleas where you're being prosecuted. If the court finds that that evidence was seized in violation of your rights, it will be the Commonwealth will not be permitted to introduce it against you, and more often than not, it will result in a dismissal of your charges. If you believe that you are being prosecuted in a case where evidence has been illegally seized from you, it is critical that you discuss this matter with your attorney, or feel free to contact us at info@pittsburghnormal.org.
Thank you.